The Law and You. A look at laws in St. Vincent and the Grenadines which affect our daily lives. The Law and You. Presented by lawyer panel P.R Campbell QC. And brought to you on SVG-TV as a public service.
Ladies and gentlemen, brothers and sisters, boys and girls, greetings. Welcome to another presentation in this public service nation-building series, The Law and You. This is program number 832, coming to you on Monday the 25th of July 2016. On this program, I will speak to you on the topic, the importance of proper procedure. But before getting into the topic, a very few preliminary comments. Obituaries. I want to send my deepest condolences to two families in particular, the family of Mr. Fred Trimmingham, who passed away recently, top sportsman in St. Vincent and the Grenadines, and the family of Mrs. Cartiel Trotman of Trotman's Electronics, both of whom I have known for a very long time. And let me remind you of the funeral this Sunday coming here at St. Joseph Spiritual Baptist Church at Lomans Windward of Mother Haywood, the wife of Bishop Godfrey Haywood. I want to leave it there for preliminaries, except no, I probably shouldn't make this complaint. I want to register a complaint about the picture quality of the recent broadcast of the test match on SVG-TV. Now, like many persons, I am forced to look at SVG-TV through channel 110 because I'm on cable. And I thought something was wrong with the TV because the image on the screen was fuzzy throughout the broadcast, until I understand that those who are getting the program directly, who I'm almost tempted to say who are blessed by not having cable, get a clean, clear, sharp image. So let me appeal to the authorities who are responsible for cable. When you put through SVG TV, try and do it properly, man. I mean, I don't want to say it's sabotage, but it's really suspicious the way that every other channel is sharp except channel 110. Please. Now let me get into the topic for the evening. The importance of proper procedure. On the 19th of July, last week, a judgment was handed down by Her Ladyship Justice Pauletta Lands. She's now on the Court of Appeal, but when she did the case here in St. Vincent and the Grenadines, she was a High Court judge. In the case involving a student who had been expelled from the St. Joseph's Convent School in Maricourt. I think by now everybody knows about that. The judgment was covered in all three newspapers. Unfortunately, I haven't seen the text of the judgment itself as handed down by the judge, but in comparing the reports of all three newspapers, they all have reported in direct speech the final paragraphs of the judgment. So I have reason to believe that they were accurate. All three newspapers could not be wrong. Now, that case was decided on procedural grounds, not on substantive grounds. The case wasn't about what the student did or said or didn't do or didn't say. The case was decided on the procedures that took place after the incident or incidents which led to the student's expulsion from the institution. A few weeks ago, a decision was handed down in the election petition cases. And that decision also was based on procedure, not substance. In fact, the complaint in the election petitions was based on alleged faulty procedure. And going back 2 years or so, less than 2 years, a very important decision was handed down by the Privy Council in London on the appeal made by Sir James Mitchell in the Otley Hall inquiry matter. That also was a case decided on procedure. So the point I wish to make in this program, as I have made before, and I will remind you of previous broadcasts, is that in law, there are many, many cases in which how something is done is as important as what is done. And the people have a saying, it ain't what you do, it's how you do it. So there are many, many cases in which proper procedures have to be followed. And if they are not followed, the law would hold that what was done as a result of improper procedure was unlawful. Excuse me. Now, back in, and I have the exact date, on the 7th of December 2009, program number 575 of the Law and You was on the topic Audi Alteram Partem. AUDI ALTERAM PARTEM. And that is a Latin phrase which roughly translates as hear the other side. And on that program, I was at pains to indicate that proper procedure requires that when anybody is accused of something, they be given an opportunity, an ample opportunity, to speak on their behalf before a decision is taken, before their guilt is presumed. Hear the other side. Now, that has been a fundamental Christian principle. I want to take you back to the Gospel of St. John, chapter 7, verse 51. Nicodemus was speaking. And Nicodemus asked the question, doth our law judge any man before it hear him and know what he doeth? Repeat. Doth our law judge any man before it hear him and know what he doeth? John 7, verse 51. And if you go right back to Deuteronomy, you will see, and Deuteronomy is full of the laws given to Moses, there were specific injunctions about evidence. In fact, Deuteronomy lays down that you cannot condemn anybody on the evidence of one witness alone. You have to have at least 2 witnesses before you can condemn any man of any offense known to the law. And if you want to check it out, you can check out Deuteronomy 19 from verses 15 to 21. Again, other references, John, the Gospel of John, chapter 8, verse 17, the Gospel of Matthew, chapter 18, verse 16, showing the importance of the testimony of at least two witnesses. And Jesus himself repeated those laws from Deuteronomy to reinforce the point of the importance of having proper evidence, proper procedure. I apologize for my voice. I'm not really but now, so we have had 3 cases in the fairly recent past in St. Vincent and the Grenadines, showing how important it is that proper procedure should be followed. Let us begin with the last one, the case of the student from St. Joseph's Convent. This is what the papers have quoted from the judgment of Justice Lands. The judge said, I am satisfied that the claimant has shown that her right to be heard or to a fair hearing has been infringed. Not only did the defendants fail to give the claimant notice of the meeting to expel the student from St. Joseph's Convent so that she could adequately prepare herself, but they failed to give her reasons for the decision to expel, the judge stated. Even if the defendants had no duty to give reasons, as the defendants have submitted, this did not affect their duty to act fairly. In coming to their decision to expel, the defendants took irrelevant factors into account and failed to consider relevant factors. As a consequence of the defendant's failure to consider relevant factors, the student was met with punishment that was excessive and disproportionate, having regard to the purported conduct of the student and the sanctions for such conduct specified in the handbook, the judge said. Well, I have the same quotation repeated in all 3 of the weekend newspapers. The Vincentian, I was reading you from the Vincentian, but the Vincentian, the News, and the Searchlight. So what the judge ruled in that case is that meetings were held, decisions were taken, but no adequate notice was given to the student or those responsible for her of those meetings. They were not involved in the decision. They didn't have a proper opportunity to make their case. And the law is clear on that point. Persons against whom disciplinary measures are proposed or contemplated must be given an opportunity to be heard. The right to a fair hearing is a fundamental part of due process. And I will refer you to programs 774 and 775 of the Law and You, heard on the 2nd February 2015 and the 9th February 2015 on the topic due process. Now, going back to the election cases, what was alleged basically in the election petitions is that proper procedures were not followed after the voting was closed. Mind you, and this point has to be emphasized because the matter is going on appeal, and in due course we will hear what the appeal court would have to say about that. No complaint is made that the voting procedures were at fault, were not proper. Nobody said that X number of people were turned away from the polling station and didn't get the opportunity to vote. Those would have been substantive complaints. What was said basically in the petition has to do with alleged wrongful procedures after the voting, after the polls were closed. It was said that ballots were not initialed either as they should have been or in the place where they should have been initialed. It is said that ballot boxes were not sealed the way they ought to have been sealed. It is said that persons for one side were not treated fairly at the recount. Now, those are procedural matters, albeit important. The way the petitions were challenged by the government side also had to do with allegations of improper procedure. The government side said that the election petitions were not properly presented because the sureties were not properly signed up, basically. They allege that the petitions were bad in law because proper procedures were not followed. They allege that the petitioners, the two candidates who brought the petitions, signed their own recognizance, and that should have been done by sureties. And election laws governing election petitions are extremely strict. So again, we have complaints based not on substantive allegations, but on allegations that proper procedures were not followed. I hope you don't think I'm belaboring the point, but I'm stressing it so that you understand that law is complicated, and some aspects of the law have to do with the way things are done or not done, and not with what has been done. In other words, many legal disputes are won or lost on procedural grounds, not on substantive grounds. Generally, procedural grounds are referred to as technicalities. And usually in criminal cases, when defense counsel prepares a criminal case, defense counsel tries to see if proper procedures were not followed, so that they could use those breaches of procedure as important loopholes to try and secure the acquittal of their clients. That is where people sometimes say law is a game, and to be honest, there are many times in which it really is a game of wits. Let us go back to the Sir James Mitchell case, and I have a copy of that judgment here. The judgment was handed down by the Privy Council on the 18th of December 2014. And the citation of the judgment is 2014 UKPC 43, United Kingdom Privy Council, case number, decision number 43 for that law. And let me read you the closing of the judgment, what the Privy Council said. Well, let me give you in a nutshell to remind you what it was all about. Before the inquiry had been concluded, and before Mr. Mitchell had gone to give evidence, remember he had challenged the summons to him to give evidence. The commission, the one-man commission, Sir Ephraim Georges, published an interim report. And in that report, he made certain allegations against Mr. Mitchell. And Mr. Mitchell's complaint was that what Justice Georges had said in that report indicated that Justice Georges had made up his mind about Mr. Mitchell's guilt of certain allegations before he had heard from Mr. Mitchell himself. So the case didn't have anything to do with the substance of what happened at Otley Hall. It had to do with allegations that Mr. Georges spoke out of turn, that he said things which he ought not to have said, which Mr. Mitchell did not have the opportunity to rebut or to respond to. This is what the Privy Council said. Paragraph 43 of the judgment. While the opinion of the board means the Privy Council, depends upon the contents of the interim report, that opinion is confirmed by the surrounding circumstances, in particular the proximity of the report's release to the election and the summon letter. The summon letter was relied on in the courts below on the procedural fairness issue, as evidence of the fact that the appellant had been invited to rebut the evidence against him. And so it did not matter that he had not given evidence by the time of the interim report. But, as appears from the passages quoted above, in the opinion of the board, in the opinion of the Privy Council, it is also evidence of the fact that the respondent, that is Justice Georges, had not changed his mind. The fair-minded and informed observer would be fortified in his conclusion, based on the interim report, on reading the similarly strong language contained in the summon letter, with its reference, for example, to, quote, the naked deceit displayed by yourself, that is Mr. Mitchell and others, unquote. Conclusion, paragraph 44. The extracts from the interim report set out above strongly support the conclusion that, having regard to the context and all the surrounding circumstances, the fair-minded observer would conclude that there is a real possibility that the respondent, Justice Georges, had made up his mind by the date of the interim report that the appellant, Mr. Mitchell, was at the heart of the wrongdoing which led to the project and its collapse, and would not be willing to change his mind so that his final report would not be impartial. In these circumstances, the Privy Council will humbly advise Her Majesty that Mr. Mitchell's appeal should be allowed. So the Privy Council said that Justice Georges had written things in the report which show that he had made up his mind. And that was even before Mr. Mitchell had given testimony, and therefore that was procedural unfairness, in that a body which has a decision to make cannot make up its mind before it has heard all of the evidence. And on that basis, Mr. Mitchell's arguments, which were rejected by the High Court and by the Eastern Caribbean Court of Appeal, the Privy Council said Mr. Mitchell's arguments were sound. Due process means that things have to be done the right way. And if things are not done the right way, then everything that flows from doing things the wrong way would be null and void. So in conclusion, procedure is very important. And doing things the right way is in many cases as important as the decision itself. Not in every case. There are some cases where, according to the rules, you can excuse departures from procedures. It all depends on the circumstances and the nature of the matter that is being dealt with. But in most cases involving people's rights and freedoms, proper procedure must be followed. Otherwise, what happens by following improper procedures can be nullified. As in the case of Mr. Mitchell, as in the case of the first ruling in the preliminary matter in the election petitions, which of course is on appeal, and we don't know what the Court of Appeal would say. We have to wait and see. But in the case of the student expelled from St. Joseph's Convent, now of course that judgment is very fresh and we do not know if there will be an appeal from the judgment. But for the time being, the three cases, Mr. Mitchell, the election petitions, and the St. Joseph's case, illustrate the importance of following proper procedures. So that is all from this program of the Law and You, program number 832. I look forward to being of further service to you next week, Monday, DV. Will next week Monday be August Monday? No, not next week Monday. Next week Monday is August Monday. By coincidence, next week Monday is a holiday. The following Monday, which really should be the 8th of August, I look forward to being of further service to you on that occasion for another presentation in this public service nation-building series, The Law and You. Do have a pleasant week. Do have a meaningful August Monday holidays, restful, peaceful. And may the good Lord continue to bless us all.
The Law and You, a look at laws in St. Vincent and the Grenadines which affect our daily lives. The Law and You, presented by lawyer panel P.R Campbell QC and brought to you on SVG-TV as a public service.